The question is that the motion be agreed to.
Mr. Speaker.
The Honourable David Parker.
Thank you, Mr. Speaker. The Labor Party is supporting this bill at first reading to Select Committee. I've got to say that the area of conflict of laws between different jurisdictions is an area where I feel more ignorant than virtually any other area of law. So I hope I don't make a fool of myself in this contribution, and I'm sure if I do, that Mr. Finlayson, the Attorney General, will correct me in my errors. Can I thank the member who brought this bill to the House for his contribution then? I thought that was helpful. I've got a number of questions that the Attorney might be able to answer if he's going to take a call. The first is that this applies for the purposes of private international law. And one of my preliminary questions, it might seem pretty obvious, but it's not to me, is whether that means international law to do with private dealings as opposed to public law involving states. If that's what it means, the Attorney nods. My alternative proposition was that it was somehow to do with private contractual relationships or disputes arising that might have a tortious element, where nonetheless there's some underlying private agreement that in the event of a dispute, that dispute is resolved in a particular jurisdiction, which is nominated in an arbitration agreement or something like that. So I suspect it's the former, that it's private rather than as between states, but it's one of the things that the Attorney might clarify and will be checked at Select Committee. The second question I have, if it's not about the where there is a choice of forum, I'm less than perfect in my knowledge as to how it is that in New Zealand someone can sue in respect of a tortious action causing loss that arose in another country. Because I would have thought normally the action would actually have to be brought in that other country rather than brought in New Zealand, and that if you were to issue proceedings in New Zealand, and no matter which law you apply, I would have thought that the other country where the tort applied wouldn't enforce the judgment, because they'd say, hey, that should have been determined in our courts rather than yours. So perhaps the Attorney can elucidate that issue as well. In terms of the cases that the member referred to, I haven't read either. Thank you for bringing them to our attention, because you could even shoot me a copy, because I'd be quite interested to read them so that I understand this area of law a bit better. Because if this is going to proceed into law at subsequent readings, I would hope that Parliament has a better level of understanding than I've got at first reading, and those cases may assist. I do take cognizance of the article that the member referred to that Chapman Tripp prepared, and I've read that. It's very brief, and it doesn't really take me much further into the underlying principles, although I do take solace from the fact that, as the member David Bennett said, similar changes have already been made in Australia, Canada and England, and I presume that the drafting of this particular bill is based on those provisions that are in those amending legislation in either Australia, Canada and England, and I would expect that the provisions in each of those amending acts in Australia, Canada and England themselves are similar, because I would have thought the same principles apply in those Commonwealth jurisdictions as apply in New Zealand. And if they've been trying to cure an ambiguity in their law, then presumably they've got to, I would hope that they've got to the same place as was being proposed here. And if they haven't, then we're going to have to look very carefully as to whether we've got it right or wrong if we're different from them. So I don't propose to expose my ignorance by pretending to properly understand the complexity of the existing double actionability rule. I've never studied it. I understand that the basic principle is that presently in New Zealand can hear the claim only if the tort is actionable in both jurisdictions. and that's being changed in the way that David Bennett has described, and that's set out in clause 7 of the bill. I understand, that in deciding which law to apply in the dispute that's being determined in the New Zealand law, if it's a tort in respect of a cause of action for the damage of property, then the laws to be applied by the New Zealand court are the laws of the jurisdiction where the property was damaged. And I understand that, I just don't understand how it comes to be litigated in the New Zealand courts. So, and I also understand the logic of if it's another cause of action, then the law of the jurisdiction in which the most significant element or elements of those events occurred. I can understand the possibility that there are torts that cross jurisdiction, and therefore part of the cause of action may arise in one country and part may arise in another country. My analysis of that might be wrong. There might be two separate torts, one in another country and one in each country. Sir, the displacement rule, again, I understand that we are conferring upon the court a discretion to say that the general rule, which has been changed, so the old general rule is being repealed and we're putting in place a new general rule, which I've described, that general rule can be displaced if in all the circumstances the court thinks that it's substantially more appropriate for the applicable law for determining the issues to be the law of the other jurisdiction, notwithstanding that the general law rule that's set out in clause 7 would have had a different effect. Mr. Speaker, I'd be interested to understand from the attorney, who I think may have had a hand in this bill, as Mr. Bennett averted to, as to why in practice this is necessary, and give us some examples of how this would have either changed outcomes or made the rights of people who have suffered or alleged to have suffered tort, as to why this is necessary. Thank you, Mr. Speaker.